the Lancaster Agreement between Zimbabwe and Britain. Maybe I'll get Safo to tell us a bit about it. So just give him a microphone so that he can tell us about the Lancaster Agreement. Then we can go to Sabah because we don't have it on the document. And then, so we are talking about the Queen's legacy here within the context of Africa's relationships with Her Majesty. So we have looked at independence of Ghana, and then we have looked at the Zimbabwe. Come over. And then, so tell us about the Lancaster Agreement.
Okay, so Paul,
you have to speak in the microphone.
Okay, so Paul, if you look at the Lancaster Agreement, it traces back from the 1930s, where there was an appropriation act by the British. So the lands which the indigenous Zimbabweans were occupying were given mostly to white farmers. And they were about 480,000 people and approximately occupying about 50 million acres of land. And the native lands, which were not as fertile as the arable lands which the white farmers were using, were given to the indigenous population. So you have over 2 million people sharing about a very small acres of land as compared to the white farmers. So in the Lancaster Agreement was between the British, the ZANU-PF, which was led by Mugabe. Then there was a third party. They were both fighting.
So the Lancaster Agreement was to correct this 1930 situation.
Yes, but then it was going to be in such a way that in the first 10 years, because the Lancaster Agreement was not only about the land, it was about giving independence to Zimbabwe in 1980.
Yeah.
So then a clause was put in the agreement by Margaret Thatcher's government that for the first 10 years where you are elected, whoever becomes president, you do not touch the land.
Okay, the land that is controlled by the British.
By the white farmers.
Don't allow the white farmers to work.
If you are going to touch it, you are going to do the willing buyer and the willing seller. That means you are going to buy it, but you are going to buy it from the white farmers.
At a commercial rate.
Good.
But they have to be willing to sell.
Exactly.
So if they are not willing to sell, there's no purchase.
Mugabe was very reluctant about it because he wanted to go back to the guerrilla war.
Yeah.
He wanted to go back to the guerrilla war, but then he was convinced by the British government that, oh, don't worry, we are going to fund it. We are going to raise money with our allies. Over $2 billion was promised. So that was what convinced them to enter into the Lancaster Agreement. Because
what was the $2 billion to be paid for?
So that means the Zimbabwean government is not going to incur the cost. So that means the British would be paying off or will be giving more of the compensation to the white farmers. So it doesn't come at the cost of the Zimbabwean government. And that's
why do they going to compensate white farmers?
Because they wanted Mugabe wanted the lands back to the native black people.
The control of the native black
exactly people. After the 10 years.
After the 10 years.
Exactly.
And therefore the farmers who have held it for 10 years needed to be compensated.
Exactly.
And Britain said they would pay the compensation.
Exactly.
So Mugabe knew that after 10 years, land will come straight to
they are going to share it to the local people. But then something interesting happened. It seemed like there was a different government in power than Margaret Thatcher had given way for Tony Blair.
Yes.
And
there was John Major before Tony Blair. Yeah.
But after the 10 years, it was Tony Blair.
After 10 years of Thatcher, it will be Tony Blair. Yeah.
And they were very reluctant to do that. They said that they didn't agree with that kind of colonial relic. And by the minister in charge of international affairs, Miss Short, she said something about she being Irish and the fact that they come from people who are colonized. They are not colonizers. So they did not really share in that idea. And there were also complaints that, you see, in the first 10 years when they were buying the lands from the white farmers, there were criticisms that this land were being given to political cronies and not the people
of the
who really
ZANU-PF,
needed it. Exactly. And not people who really needed it. And because of that, they are not going to be interested in that. So Mugabe felt like they didn't hold up to their end of the bargain. And so in the early 2000s, there was this violent compulsory acquisition of land, which would later lead to a lot of violence, and it will later cause Mugabe in he even losing his knighthood, which the Queen had already given him.
Oh, they withdrew their knighthood from Mugabe.
Exactly.
When he stuck a claim for the land of his people.
Human rights abuses and also his violence with Morgan Tsvangirai. So that's there.
And all Mugabe was trying to do was to get the Lancaster Agreement obeyed.
Exactly.
Yeah.
Exactly.
That's interesting. So how do we contextualize that in the legacy of Imperial Majesty?
Well, you see, the funny thing is Mugabe never actually criticized the Queen.
on this one.
And Mugabe is a very loud person.
No, the Queen is not very easy to criticize.
Yes, but he criticized the government. He called them immature.
Yes.
He called them very immature.
No, he had exchange of words with Tony Blair at international fora.
Yeah.
Yes.
So keep your Britain and let me keep my Zimbabwe.
Yeah, but that's because Tony Blair is representing the government.
Yeah.
But the owner of the land is His Imperial Majesty.
But then there are also views, if you check Zimbabwe, there are conflicting views. People blame the politicians, like I've said, but also people say the Queen is an embodiment of the British rule. So if there is anything that goes on in Zimbabwe, she could have done something about it. She could have said something about it, but she never acknowledged it. She never addressed it. And so for that, you have people on the other side who blame her. So it's split just like it's in most African countries.
Let's thank you very much, Safo. Let's now find out why we don't have that problem in Ghana. Put up John Mensah Sabah here. So you heard his narrative, very interesting one. We're going to put it in text, but I'm going to tell you why we don't have that land problem with Ghana. Then you can understand why John Mensah Sabah is great. Okay, so let's start from here, and I hope I can run through very quickly. On 14th November 1894, therefore, a bill entitled An Ordinance to Vest Wastelands, Forest Lands and Minerals in the Crown was read in the Legislative Council for the first time. It was provided in Section 3 of that bill that all I'm not getting the thing well. Ownerless land is what they were trying to say. And forest land in the colony are hereby vested in the Crown for the use of the government of the colony. So this is the bill in Section 3. They say that all waste lands, I think is waste, W Ransford next time. All waste lands and forest land in the colony are hereby vested in the Crown. Every wasteland, what they call wasteland, is land that has not been occupied. That's how they call it, wasteland. It's vested in the Crown, isn't it? Okay. And then it says under Section 2 of the bill, wasteland was defined as land of which for a period of 30 years before the commencement of the ordinance, no beneficial use had been made for cultivation or in habitation, or for collecting or storing water, or for any industrial purpose. So that's what they call wastelands. Wastelands is 30 years before then, nobody has been on it. So at that time, 1894, where was Accra? Accra was only Accra Central. So all the areas in Hacho, Adenta, Labadi, and Baman Probi, all those places, the British law was calling it wastelands. And they said that all wastelands will be owned by Her Majesty the Queen Victoria at the time. Okay, so let's see what happened. All right, on 9th April 1895, the King, chiefs and inhabitants of Cape Coast dispatched a strongly worded petition to Her Majesty's Principal Secretary of State for the colonies. This petition was drafted and dispatched on the advice of Sabah, who was at that time working in collaboration with the chiefs and people to resist what they considered as a serious and unprecedented encroachment on their birthrights. Meantime, in Accra, a deputation of chiefs and headmen had been received by the governor, Sir W. Branford Griffith, who was told by the opposition to the bill by the people of Accra. In all parts of the colony, people fenced their land and burned the bush upon it. This was the method of preparing for land cultivation. The people resorted to this method not only to indicate that beneficial use had been made of their land, but also to show that their lands did not come within the definition of the land which had been lying waste for 30 years before the passing of the Crown Land Bill. I'm sure that you are following the arguments, isn't it? The British said that all lands that have not been occupied is wasteland, is going to their majesty. That's what happened in Zimbabwe. Then that's what the Lancaster Agreement was supposed to correct. In Zimbabwe in 1930, they were able to successfully pass the law. In Gold Coast in 1897, they were not able to pass the law. I'll show you why as we go along. Okay. The reply by the Secretary of State to the petition was based on the wording of Sir W. Branford Griffith's comments. The governor was to inform the petitioners that whilst fully respecting the views put forward by the native authorities, the Secretary of State was unshaken in his conviction that in order to protect the forest from injury by reckless felling of timber, and in order to preserve waste and forest land and minerals from being unwisely dealt with, it was necessary to introduce legislation to deal with the situation. That's very interesting. The Secretary of State said that he's unshaken by what the chiefs are saying. Are they all right? They have all these lands. How do you protect the forest? And Secretary of State is sitting in the United Kingdom. He's telling the Fanti and the Ga chiefs that I have better ways to protect your land. That's what has happened in Zimbabwe. And why it didn't happen in Ghana is the reason why I'm bringing back this situation. That's what the Secretary of State wrote back to them. He said, I am unshaken in my belief that this has to be legislated, and legislated according to the way that the bill proposes, that all wastelands, lands that have not been occupied 30 years before the bill, all over the colony, belongs to the Queen. Okay, let's move on. It says, it was to be emphasized that the government had not contemplated interference with any existing native rights of property. In order to allay the suspicions of the natives in this regard, an assurance was to be given by the government that in the administration of the law, the colonial government will deal with care and prudence and with a conciliatory disposition, and remedially where necessary and on their merit with any cases of hardship submitted to it. Later in July 1897, the Secretary of State for Colonies, Mr. Joseph Chamberlain, made a statement in the House of Commons to the effect that he had given his approval to a policy which will make it impossible for any native chiefs to grant concessions without the prior consent of the governor. This is the story. This is how it went. Whereas this time-honored and effective custom has for some time been set aside and superseded by Gazette, and whereas a large majority of the population of the Gold Coast Protectorate are still unable to read, and whereas even the greater part of those able to read, now this is a Aborigines Right Protection Society, cannot all comprehend the meaning of the bill passed from time to time by the government, the above society, which is the Aborigines of John Mensah Sabah, of which the natives and the residents alike can be members, has been formed to discuss the various bills intended to be passed by the government from time to time with a view to fully understand the meaning, purport, object, and effect thereof, so that every person may have the opportunity to understand the same. The opposition to the Lands Bill of 1897 mounted in the whole colony, and the kings, chiefs, and the Gold Coast Aborigines Rights Protection Society briefed John Mensah Sabah as counsel for a fee of 400 guineas. What does it mean? To appear on their behalf before the Legislative Council and to submit their objections to the bill. Sabah therefore attended the Legislative Council meeting at the second reading of the bill, and at the request of the Honorable Mr. Chidham, who presented petitions of protest from Cape Coast, Anumabo, and Abura, Sabah and Peter Wonorine were granted permission to appear at the bar of the council and to make oral representation on behalf of the petitioners. Sabah maintained that the main objection to the bill by the chiefs and people was its encroachment upon their natural rights of absolute ownership of their lands and the fundamental change of their status to that of mere holders and settlers. The bill, he contended, will not only abolish the distinction between individual, family, and communal rights to the land, but would also undermine the authority of the headmen over their villages. He continued, quote, not only are the bonds of the society be snapped, but family ties, etc., etc. Let's move on quickly. This led to Sabah. This lead by Sabah was followed in all parts of the colony. Thus, in a petition of the kings and chiefs of the Eastern Wassa, in protest against the bill, they stated, blah, 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 associating themselves with Sabah's argument, still on the Wassa matter. In his replies to the petitioners, the governor said he was not prepared to recommend the opposition of the chiefs to be taken notice by the Secretary of State, because the ordinance was one which was very much required in the best interest of the people of the colony. He, the governor, further stated that the Secretary of State had himself expressed his concern about the illegal alienation of lands by the chiefs and their people. And that's very interesting, isn't it? How does the Secretary of State conclude that alienation of land by the Asantehene was illegal, or the alienation of land by the Awo Mafia was illegal, or that the alienation of land by the Gamanche was illegal, or the Kwapimini was illegal? But that's what the governor sought to do. The governor sitting in Accra and the Secretary of State sitting in London were making determinations that allocations being made by chiefs were illegal because they said that land was ownerless. This is what happened in Zimbabwe that we just talked about. And okay, let me finish. His Excellency concluded by saying that he felt sure that in view of his explanation of the situation, the mist and cobwebs woven around the understanding of the people will now be removed. He, however, informed the petitioners that their petition had been forwarded to the Secretary of State for Colonies. On 25th April 1897, the Secretary of State for Colonies sent a telegram to the governor in which he said that he approved generally the Lands Bill 1897, but that the governor should wait for a dispatch before passing it. In his dispatch dated 29th April 1897, the Secretary of State for Colonies suggested some amendments and subject to those observations. He advised the governor to proceed with the ordinance if no appeals or protests against it had in the meantime been received or sent to London for consideration. When the bill was in the committee stage, the governor dispatched a telegram on the 5th of June 1897 to the Secretary of State for the Colonies in which he asked permission to proceed with the bill on condition that it had a suspending clause. To this telegram, the Secretary of State for Colonies sent his reply on the same day. He said, better course will be finish committee stage of bill, then refer it with protest to me for instructions. No time will be lost by doing so. The bill was in due course submitted to the Secretary of State for Colonies, and in 1898, the chiefs also sent a deputation to Downing Street, London, to press further their objection to the bill. Okay, so let's get it clear. It was in what year was it? 1898, that the chiefs in Ghana sent a deputation to London. They paid for people to go to London in 1898 to go and protest against the land bill. You see why Ghana was different from Zimbabwe? Okay. The chiefs acted on the advice of Sabah, who through sheer modesty declined to lead or accompany the deputation, which was made up of J.W. Say, T.F. Jones, and George Fuse, all of Cape Coast. In August 1898, it was announced amidst wild rejoicing that the Lands Bill 1897 had been disallowed. However, the Concessions Court, which was also proposed in this bill, was established by the Concessions Ordinance of 1900. This is Say, J.W. Say, the disallowance of the bill 1897 was a personal victory for Sabah. And to him and other leaders of the Aborigines Rights Protection Society, this country owes a perpetual debt of gratitude. And when Sabah returned to Cape Coast from Accra, after presenting the case of the chiefs and people before the Legislative Council, he returned to the Secretary of State of the Aborigines Rights Protection Society the handsome fee of 400 guineas with a covering letter which at once reflects his political maturity and the philosophy which motivated his conduct in the defense of his country. The letter read as follows: Mr. J.P. Brown, Vice President, Gold Coast Aborigines Protection Society. Dear Mr. Brown, by the bearer you will please receive the retainer given to me when I was instructed to proceed to Accra, and there appear at the bar of the Legislative Council to urge reasons against the Lands Bill of 1897. As you are aware, I was very reluctant to go to Accra when my assistance was sought the first time, because I had not fully ascertained to what extent our countrymen were in earnest in their opposition to the Lands Bill, or now far determined by lawful means and methods to avert what they rightly and conscientiously believe to be a pernicious legislation. When, however, I was fully convinced that they were never so united nor so determined in all parts of the country, I left home to do their bidding. I do not spurn or refuse, blah, blah, blah. Okay, so Sabah eventually returned the money. He said, when my lamented father was a member of the Legislative Assembly, he defrayed his own expenses whenever public duty called him to Accra, for which reason your committee and the king's chiefs and others who engage my services need not offer to defray my traveling expenses. Allow me to offer one suggestion to your society, and that is, no effort should be spared to devise means whereby every native of the Gold Coast may acquire a correct and true knowledge of the constitutional history of his dear native land. Very, very interesting. John Mensah Sabah wrote this in 1897, that his desire is for every Gold Coaster, later on Ghanaian, native of the Gold Coast, may acquire a correct and true knowledge of the constitutional history of his dear native land. Those who came to power and cancelled history as a compulsory subject, they didn't read John Mensah Sabah. John Mensah Sabah was talking about how the knowledge, the history of the knowledge of Constitution is important for every native of the Gold Coast. That's a great man right there. And so that was how Sabah actually gave, that's John Mensah Sabah, the man who actually gave us our land and gave us the authority to preside over our own lands. That was Sabah. Great, great, great man. in terms of the context of the colonial history. Let me.